Good afternoon, and thank you all for joining me for this talk in conjunction with the Junior PLA. Firstly, thank you for taking the time out of your Wednesday afternoon to learn about vesting orders. I will do my very best to make the talk as painless as possible, albeit, as you'll soon discover, the law relating to disclaimer of property and subsequently vesting that property in an individual or a company is quite complicated in practice and really rather antiquated. I'll do my best to keep the Latin to an absolute minimum, although sadly that won't be entirely possible. And in fact, had I given this some more thought, I had the technological know-how, I would have had a QI style klaxon that goes off whenever Latin rears its head. But perhaps we can arrange that for the next time. Given it's a webinar, and just to give you some indication, I intend to keep the talk to roughly 30 minutes. Secondly, I think the plan was initially to host this in person, with, I'm told, several types of alcoholic beverages waiting in the wings. Sadly, that hasn't been possible for one reason or another. However, I hope if I'm invited back by the association, I can meet some of you face to face over something slightly more stimulating than a glass of water. Now, the purpose of today's presentation is to give you a high-level overview of all things relating to vesting orders. That is, the process by which property can be vested in an individual or a company, having been disclaimed by either the liquidator or the Crown. There is a lot to unpack with this topic. So just as some headline notes, I'm going to be discussing reasons why a company might be struck off the register, so the circumstances that would give rise to a possible vesting order. What happens to property held by the company when it is struck off? And the short answer is it becomes bona vacantia. That's the first Latin klaxon of the afternoon. What type of property can become bona vacantia? As we'll see, the answer is not necessarily as straightforward as one might hope. And then disclaimer, what this is, how that's done in practice, and importantly for your clients, the implication of property being disclaimed. Now, once we have an idea of what happens to the property, we then move on to steps that can be taken to recover it. And to that end, we'll be discussing the restoration of a company and vesting orders under various statutory provisions. So the Insolvency Act, Companies Act, the Law of Property Act, and lastly, the Trustee Act. And so as you can see, there's quite a lot to cover. And so with that in mind, I intend to get straight to it. Now, it's perhaps helpful to just set the scene and give some examples of the types of situations that give rise to vesting orders. Of course, we start with a company being struck off. Now, a company may be struck off the register for any number of reasons. For example, it might do so entirely voluntarily for legitimate reasons, such as a corporate restructuring, where the intention behind the company becomes redundant, or it merely ceases to trade. However, what if the company inadvertently fails to dispose of its property prior to it being dissolved? Or, and sadly I've seen this more than once, owing to inadequate record keeping, the appointed liquidator simply isn't aware of property prior to dissolving the company. Or an extension of that, the liquidator becomes aware of the property only after the event. In those types of situations, restoration of the company or a vesting order may be appropriate. And whilst on the topic of inadequate record keeping, a common scenario, particularly in context of vesting orders, is where a company is struck off involuntarily for failing to make periodic filings with Companies House. The involuntary strike-off process is contained within sections 1000 and 1001 of the Companies Act, and that's made reference to on the slide. In essence, the registrar has the power to strike off a company where it has reasonable cause, and that's important, to believe that the company is not carrying on a business or an operation. And the easiest example of that is not filing your annual accounts or returns. So that just gives you a flavor of the type of scenario that might set the foundations for a vesting order. But what happens to the property in those circumstances? As I said earlier, the simple answer is that it becomes bona vacantia. In other words, ownerless goods. The relevant provision is contained in section 1012 of the Companies Act. And again, that's set out on the slide. But what type of property in practice are we talking about? It's actually very broad. So it can include land, bank accounts, shares, intellectual property. It's all capable of becoming bona vacantia. What cannot is property held by a now dissolved company as trustee for someone else. So where, for example, property is held pursuant to a trust, we can rule out bona vacantia. It is expressly prohibited by section 1012, subsection 1 of the Companies Act. In those circumstances, the property escheats to the Crown estate. Now, I know what you're thinking. We have the second Latin klaxon of the evening. And what on earth does escheat mean? Now, I'll come on to talk about it a bit later on, but bear that phrase in mind, escheat. Sticking with property for a moment, the application of section 1012(1) is so broad that property held overseas but owned by a former company registered under the Companies Act may also become bona vacantia. Albeit this raises a number of conflict of laws points, which, whilst are incredibly interesting, we simply don't have the time to cover today. But as I'll explain at the end, I'm more than happy to deal with any follow-up queries and provide my notes, particularly in respect of cross-border issues, because it's actually rather interesting. Sticking with overseas matters for a moment, real property held within the UK, but owned by a foreign entity, can also become bona vacantia. However, unlike with companies registered under the Companies Act, the freehold property held on trust by a foreign company that is dissolved does not escheat to the Crown estate. Instead, it vests in the Crown as bona vacantia, subject to a trust. And the authority for that is Hamilton and Her Majesty's Attorney General from a case from last year. So the position is the polar opposite of a domestic company. When we're dealing with domestic companies, the land escheats. Where we're dealing with foreign companies, it devolves to the Crown as bona vacantia. So we have a pretty clear idea of when and how property becomes bona vacantia. What happens to it then? The answer is wonderfully feudal in the sense that it is dealt with by the Crown. And by the Crown, we mean the Duchy of Lancaster or the Duchy of Cornwall. As to whose jurisdiction it falls under, this depends on the last registered address of the company at the time that it was dissolved. Now, whilst this all sounds terribly British and with great pomp and ceremony, in practice, the property is dealt with by the bona vacantia division, which itself is a branch of the government legal department. Now, the Crown, or again, through the BVD, may either take steps to sell the property for market value, or it can disclaim the property under section 1013 of the Companies Act. In practice, the Crown is highly unlikely to be aware that bona vacantia has ever vested in it. It will only become aware once it has been notified of that fact. And even in circumstances where it does become aware, the Crown's unlikely to action anything in respect of the property, unless, firstly, the property has some market value, and secondly, that market value is worth the cost of selling. In a nutshell, unless there's money to be made, the Crown isn't interested, and it will invariably disclaim the property. Now, before turning to disclaim and disclaimer, and what we mean by that and its effect, there are two miscellaneous points to note in respect of the Crown. Whilst the property may become vested in the Crown, it does not assume a fiduciary responsibility in respect of the property. And that position was explored in the case of Pottier from 2021. In essence, in that case, companies that owned shares were dissolved. And as we know, shares are property that are capable of becoming bona vacantia. And in this case, they did. They devolved to the Crown. And the company's former shareholder had a previous court order vesting those shares in the shareholder. And the shareholder asserted that the Crown was aware of that order and therefore held those shares on constructive trust. However, the court held that as the Crown does not voluntarily assume a fiduciary responsibility, no constructive trust arose. So therefore, any claim that the Crown holds property on constructive trust for an interested party is more than likely to fail. The door hasn't been completely closed in respect of that submission, but chances are it's likely to fail. The second point is that the property devolves to the Crown subject to any perfected security interest. Accordingly, should the Crown take steps to sell the property, it will be sold subject to the security interest and the secured creditor paid off. That way, no prejudice is caused to the creditor, and any surplus simply passes to the Crown and no doubt lines the Treasury's coffers. Now, I previously mentioned the options available to the BVD, that being to sell the property or disclaim it. Disclaimer essentially means to determine the rights, interests, and liabilities in respect of property. I'm going to touch upon two types of disclaimer. So it's disclaimer by the liquidator of a company and disclaimer by the Crown. First, disclaimer by liquidator. This is a situation that occurs prior to the property becoming bona ficantia, and it occurs during the course of the liquidation. So a liquidator's primary function is, of course, to collect in the assets of the estate, realize those assets, and distribute any surplus to those who are entitled. However, part and parcel of that function is that a liquidator has a statutory power to disclaim any interest in onerous property under Section 178 of the Insolvency Act. And I've made reference to that provision and indeed the definition of onerous on the slide. It's there for your consideration, but in essence, where the property is more hassle than it's worth, the liquidator will simply disclaim the property and wash his or her hands of it. I've included reference to Section 1784 of the Insolvency Act as well. It's clear insofar as it establishes that the rights, interests, and liabilities of the property are determined. However, the effect of disclaimer on different types of property varies. So, for example, where the property is freehold land, the property will escheat to the Crown estate. And there's that phrase again. I promise, come on to talk about this. And in terms of leases, where it is the tenant's liquidator who disclaims the interest, the lease is determined and simply comes to an end. And that is perhaps the most common example of disclaimer by a liquidator. And it's for obvious reasons. A lease naturally gives rise to a liability to pay money, and more often than not, it contains onerous covenants. All other types of property that are capable of existing independently, once disclaimed, will become bona ficantia, and it dissolves to the Crown to be dealt with by the BVD. Now, turning to disclaimer by the Crown, this is contained, the powers contained in Section 1013 of the Companies Act. The Crown can disclaim any property it does not intend to keep or sell, and that's set out on the slide. In essence, the property in respect of which there are risks and liabilities, or it's simply not cost effective to sell, the Crown will look to disclaim. And typically, this will be private roads, common parts of an estate, property that might be subject to onerous covenants, or indeed property that's in negative equity. That is all property that the Crown will look to disclaim. And indeed, the BVD published guidance, which gives some indication as to where your property might fall. Just to touch upon some procedural points, the Crown has 3 years to disclaim bona ficantia that has been vested in it. And importantly, that time period runs from when the BVD received notice that the property had vested in the Crown. So in practice, property may be vested in the Crown for some time before the clock even begins to run on the period for disclaimer. As I said earlier, the Crown is unlikely to be aware unless it receives notice that property is vested in it. So you could be talking about a significant period of time that property has actually been bona ficantia and vested in the Crown before the Crown has to decide what to do with it. Alternatively, anyone with an interest in the property may force the BVD to make an earlier decision as to whether to disclaim or not by applying in writing. And the BVD then has 12 months following the application to execute a notice of disclaimer. The BVD is not required to give prior notice of its intention to disclaim bona ficentia, and disclaimer takes effect when the Treasury solicitor executes a notice of disclaimer. That notice is then registered at the company's house, and copies are then published in the London Gazette and also sent to anyone who the BVD have been notified that they have a potential interest in the property. The rules are slightly different in respect of leasehold property, which is governed by section 1016. In essence, the BVD must serve a copy of the notice of disclaimer on every person, so far as the BVD is aware, who claims to be an underlessee or mortgagee. Disclaimer does not then take effect immediately, but rather it takes effect following service, and either there has been no application for a vesting order within 14 days of service, or where an application for a vesting order has been made within that 14-day period, the court has said disclaimer is going to take effect anyway. In those circumstances, the leasehold is disclaimed. So that's the process by which the Crown may disclaim property. But what effect in practice does it have? And section 1015 ultimately sets out the effect. In essence, disclaimer is the determination, as I mentioned earlier, of the rights, interests, and liabilities of the company to the property. However, it does not affect the rights or liabilities of any other person to the property. And that language is almost identical to disclaimer by the liquidator, purposefully. And so from a practitioner's perspective, life is made slightly easier in that the authorities applicable to one scenario, i.e. disclaimer by the liquidator, also applies to disclaimer by the Crown. And the authority for that is Mistral Asset Finance Limited. In terms of leasehold property, the effect of disclaimer is that the leasehold title is extinguished. However, as is becoming a common theme, the disclaimer does not terminate the rights and obligations of third parties with an interest in the lease. And the authority is Hindcastle Limited for that. It's perhaps worth noting at this stage that whilst the title itself is extinguished, that title can later be resurrected by restoring the former company to the register. And I'll come on to talk about how that works in practice in just a moment. Conversely, as applicable to freehold property, the effect of disclaimer by the Crown is that it extinguishes any interest in the property, and the property escheats to the Crown estate. The Crown estate is a different body to the Crown. It has different solicitors as well. Now, where the disclaimed property is subject to security, the disclaimer does not cause the secured creditor to lose any power of sale, and therefore the secured creditor is never really prejudiced by the failings of the dissolved company and the BVD's election to disclaim. That naturally follows and makes a lot of sense. Similarly, as with leasehold, this also isn't quite the end of the story. Disclaimer is not the end. Title can be resurrected by restoring the company to the register. And the case for that, as it applies to leasehold property, freehold property, is Five Star Properties Limited, a case from 2015. It's also important to note that disclaimer takes effect retrospectively. In other words, once disclaimed, the property will be treated as never having passed to the Crown in the first place. The Crown is essentially absolved and the property moves directly to the Crown estate. And that's contained within section 1014, subsection 1 of the Companies Act. The word escheat has reared its heads a couple of times, and rest assured, I say escheat with little to no confidence as to its correct pronunciation. I've referred to it several times in the Chancery Division. I haven't been laughed out of court yet, but that might be more down to the general goodwill of the Chancery Masters. Simply stated, escheat is the process by which freehold land reverts to the Crown Estate as the ultimate owner of all land. The process ensures that freehold land is never without an owner, but importantly, it only applies to freehold land. So in the situations we've discussed this afternoon, that will be where a liquidator disclaims freehold land belonging to a company in liquidation, where the Crown disclaims bona ficentia, freehold land, and where a foreign company that owned freehold land no longer exists. And when that freehold land escheats, any interest in the land is extinguished. However, the registered title of that land remains. And indeed, the land registrar under Rule 173 of the Land Registration Rules 2003 may enter a notice to the effect that the land has been disclaimed. However, whilst that notice may refer to being disclaimed, I've not seen a notice reference the property having escheated to the Crown Estate, albeit that is what's happened. So practically then, what happens next? The Crown Estate can, but is not obliged to take possession of the land. In practice, the only thing the Crown Estate will do is sell the land if it is approached by a suitable buyer. And it will only sell the land where a sale is not going to create any risk to the Crown Estate. The sale price is a fair and reasonable one. And importantly, the sale provides for the Crown Estate's legal costs to be covered. It's not going to do anything for free. Now, it's worth bearing in mind that unlike the Crown and the BVD, the Crown Estate can hold on to the land for a limitless period of time. It is, if you like, the final buck stop for freehold property. There's simply nowhere else for freehold property to go once it's been vested in the Crown Estate. So we've covered what happens to property formerly owned by a dissolved company. It becomes bona ficentia. The process of disclaimer by both the liquidator and by the Crown, and the effect of disclaimer on different types of property, i.e. it extinguishes the interest and it escheats. So how can the company, now dissolved, recover that property? As I mentioned earlier, when we were discussing the effect of disclaimer on leasehold and freehold property, not all hope is lost. It may still be possible to recover the property by restoring the company to the register. Now, for those of you perhaps a bit more familiar with insolvency law, there are two routes by which a company can be restored: administrative restoration and restoration by court order. Administrative restoration is governed by sections 1024 to 1028A of the Companies Act. Typically, it applies to companies who have failed to keep up with their filings and have been struck off. However, the process is, as its name suggests, purely administrative. It simply requires an application to the Registrar of Companies. There are numerous requirements that have to be met in order to qualify for administrative restoration. However, the crucial ones: firstly, only a former director or former member of the company can apply for an administrative restoration, and the company must have been struck off under sections 1000 and 1001 of the Companies Act. And, this is important, the application to restore is made no more than 6 years following the date of dissolution. Importantly, the registrar has no discretion to restore where more than 6 years has elapsed. Now, conversely, restoration by court order, this is governed by sections 1029 to 1034 of the Companies Act. Unlike the prescriptive nature of administrative restoration, a much wider group of people can apply to the court for the company to be restored. So, for example, that might include individuals with a potential claim against the company, the former liquidator of a company, or it can even be so broad as to encompass any person with an interest in the property. There are, again, a number of requirements. However, the application must be made within 6 years of the company's dissolution. There is an exception to this, and that's unless the purpose of restoring the company is to bring proceedings against it for damages for personal injury. In those circumstances, there is no time limit. For everything else, I'm afraid the 6-year period from dissolution is the absolute limit. If more than 6 years have elapsed, then restoration simply isn't a possibility. Now, the effect of restoring the company is that it is deemed to have continued in existence. In other words, it was never struck off. And therefore, any property that had become bona vacantia will automatically revest in the company again. The exception is where there is a foreign company that is restored under whatever relevant jurisdiction. And as I mentioned earlier, that property also becomes bona vacantia. However, it does not automatically revest in the company. So there's an exception to the rule. In those circumstances, an application needs to be made under the Law of Property Act, or where the foreign company held the property as trustee under the Trustee Act. I'll come on to discuss both of those in a bit more detail shortly. So that deals with the scenario in which the property held is merely bona vacantia. However, what about where the property has been sold or disclaimed by the Crown? In other words, where the BVD has actively taken steps in respect of that property. So where the Crown has sold the land or disposed of it, in other words, the restoration does not unwind the disposition. And that's contained in the statute at section 1034, subsection 2. So if the property has been sold to a third party, I'm afraid, tough luck, that ship has sailed. Albeit, the Crown will pay to the company an amount equal to the consideration it received for the property, minus, of course, the Crown's cost for dealing with that property. However, freehold and leasehold property that has been disclaimed, I say disclaimed rather than disposed, can revest in the restored company. And that was confirmed by the High Court in 5-Star Properties in respect of freehold and Mistral Asset Finance Limited in respect of leasehold property. In essence, the upshot of those cases is that disclaimer does not equate to disposition, and therefore the property can automatically revest in a company upon restoration. So of course, if you're ever faced with a scenario in which property seems to have become bona vacantia or even escheated and then being disclaimed, disclaimed and then escheated, restoring the company to the register should be the first port of call. That's what you should be looking to achieve. Other than restoration, there are 4 ways in which property may be vested in an individual or company. And I've set those out on the slide. And broadly speaking, the context in which each statutory framework applies. Now, starting with section 181 of the Insolvency Act 1986, this obviously applies where property has been disclaimed by a liquidator. Now, once a notice of disclaimer has been issued by a liquidator, a party may apply for an order vesting the property in that party if they claim an interest in the disclaimed property, or they have a liability in respect of the disclaimed property, and that liability has not been discharged by the liquidator. It should be noted the court will not make a vesting order where there is an ongoing liability, except where it would be just to do so for the purposes of compensating the person in respect of the disclaimer. The application must be made within 3 months from the earlier of the date that the applicant received a copy of the disclaimer notice from the liquidator, or the date the applicant became aware of the disclaimer. The procedure is similarly contained within Rule 1911 of the Insolvency Rules 2016. The rules don't prescribe anything that you wouldn't expect to see there. In essence, what's required is a detailed witness statement setting out the statutory basis of the application, when the notice was received, what steps have been taken following notice, if there's any delay, justification for that delay, and the grounds of the application. And by that, I mean, really the applicant's interest in the property. How does that interest materialize? Why should the vesting order be made? There shouldn't really be any surprises with the procedural requirements there. Turning to section 1017 of the Companies Act, as with the Insolvency Act, the court can order that property disclaimed by the Crown be vested in an individual. And now, for all intents and purposes, the provisions mirror the language under Section 181 of the Insolvency Act. So it's not too complicated in respect of that. It's the same statutory framework in essence. Now, some scenarios of when a claim might be commenced include where a creditor of the dissolved company is looking to realize certain assets, or a party that contracted with the dissolved company to buy property. So that party then provides consideration prior to being dissolved. However, the transfer is never actually effected. In those circumstances, clearly, the injured party has an interest in the property and a vesting order is appropriate. And by way of some brief practical matters, the claim should be issued in the Chancery Division of the High Court. It should be done using the Part 8 procedure. The Attorney General should be the named defendant, albeit it is highly unlikely the AG will ever take an active role. And unlike Section 181 of the Insolvency Act, there is no time limit for a claim under Section 1017 of the Companies Act. However, it is always appropriate to issue as soon as possible. And if there's any delay in issuing, it's important to explain that delay in the witness statement rather than brush it under the carpet. Turning to Section 181 of the Law of Property Act, the section provides that where property has been terminated due to the dissolution of a company, in other words, it's escheated and it's passed to the Crown Estate, the court may order the creation of a corresponding estate and vest that estate in the person who would have been entitled to the original estate had it continued to exist. The wording I find is incredibly cumbersome, but in simple terms, an individual must have a recognizable legal right or interest in the property in order for it to be vested in him. The most common example is a person who holds an option to purchase property. And indeed, that issue was addressed in Lysium Limited and the Crown Estate Commissioners, a case from 2021. In that case, the applicant was the former shareholder of a company that owned the applicable freehold. The shareholder asserted to have been a party to a transfer agreement that was intended, and note the word intended, but did not in fact transfer the former freehold to the applicant. And to that end, it was suggested by the shareholder that there had been an omission. However, Master Clerk in the Chancery Division held that there was no evidence to the effect that the shareholder had an exercisable legal right to the property, and merely seeking to establish an intention was not good enough. Therefore, the claim for an vesting order ultimately failed. And just to revisit something we touched upon earlier, when a foreign entity has been restored under the relevant jurisdiction, it is able to apply under Section 181 of the Law of Property Act for a vesting order. However, where the company held the property as trustee, it has no standing under Section 181. That is because the freehold property held on trust does not escheat to the Crown Estate. Rather, it is held by the Crown as bona ficantia. And as I set out earlier, Section 181 applies to escheated land only. So in those circumstances, the company will have to apply under Section 44 of the Trustee Act 1925. And indeed, that was set out very clearly by the court in Hamilton and AG, the case from last year. Now, lastly, under Section 44, the court has the power to make a vesting order in 7 possible scenarios. And those are set out in subsections 1 to 7. They're too numerous to cite at length, but for the present purposes, subsection 2D deals with the scenario of a corporate trustee who has an interest in land that is subsequently dissolved. Now, in that scenario, the court has jurisdiction to make a vesting order in favor of a new trustee appointed by the court or any remaining trustee, even though the dissolved trustee has not been discharged from office. Now, that's particularly so where the fund is immediately divisible amongst the beneficiaries. And that was established in Harrison's Settlement Trust, a case from 1965, which I've included on the slide. Now, historically, there has been some debate as to whether when the sole trustee has been dissolved, the beneficiaries, rather than a newly appointed trustee, are entitled to have the property vested in them directly. And one can quite naturally see the rationale behind that. That issue remains somewhat up in the air. However, there appears to have been a softening to the approach in recent years. And an example of that is the case of Hamilton and Her Majesty's AG, again, the case from last year. The court in that case was content to make a vesting order in the beneficiary of a trust, as it would facilitate the continuation of a business, rather than revest the property in the corporate trustee who had been restored. So it's a developing jurisdiction, and one where I hope we see some development in the coming years. But in essence, if it's not possible to restore the company to the register and have the property revested in that way, then naturally it falls to one of these 4 procedural routes by which you may seek to have the property vested in your client. In practice, it's more prudent to plead several in the alternative. Whilst I previously set out the application of these respective statutory schemes to certain scenarios, the facts of cases are rarely as clear-cut as that. It will always be better to plead these matters in the alternative by way of a Part A claim. So there we have it. There is, with this topic, so much material to cover. So excuse me if we've rattled through this at some pace. But by way of summary, the things that you need to be aware of: property held by a company that is dissolved becomes bona vacantia. When vested in the Crown as bona vacantia, the Crown may either sell the property or it may disclaim it. In addition, a liquidator may disclaim property during the course of liquidation, but only if that property is onerous. Now, the effect of disclaimer is to determine the rights and liabilities of the company. And as you'll recall, it's the same statutory provision, whether it's done by the liquidator or the Crown. As applicable to freehold property, that property escheats to the Crown estate. And once disclaimed, if the company is restored within 6 years of being dissolved, it's possible to revest that property in the company. Alternatively, an individual may apply for a vesting order using one of the 4 procedural steps outlined. It is not at all a straightforward area of law, and it's full of archaic jargon and procedural quirks. But that said, I sincerely hope that this talk has served as at least a suitable introduction and gives you some grounding in the area. Thank you very much for attending, and I sincerely hope you enjoy your evenings.